Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Anora Wang. Today's topic is, what roles do economists play in Chinese competition law? Conversation with economist Dr. Vanessa Zhang. China's antitrust regime has evolved significantly over the past decade, not only in its enforcement priorities, but also in the way regulators and courts rely on economic analysis. What role do economists play today in merger review, abuse of dominance cases, and broader competition policy discussions in China? How has the importance of economic analysis changed over time? And what does it mean in practical terms for economists to truly add value in Chinese antitrust cases? Joining me today is my co-host, Kathleen Hu. Hi, Kathleen.
Hi, Anora.
Would you please do the honor and introduce our guest today?
Happy to. Our guest today is Dr. Vanessa Zhang, who is an executive vice president and head of Compass Lexicon's Greater China practice. Based in New York and Beijing, she leads economic analysis on competition, industrial organization, and intellectual property matters across the US, EU, and Greater China. She has testified as an expert witness and submitted expert reports before China's State Administration for Market Regulation, the Supreme People's Court, provincial higher courts, MOFCOM, NDRC, and other regulatory bodies. In addition to her consulting work, Dr. Zhang is also a senior research fellow at the Market and Regulation Law Center of Renmin University, which provides economic training to Chinese antitrust agencies. She holds a PhD in economics from the Toulouse School of Economics and has extensive experience across multiple industries, including digital platforms, telecommunications, pharmaceuticals, and banking.
Well, without further ado, Vanessa, welcome to the program.
Thank you so much, Anora and Kathleen. It's my pleasure to be here. Thank you so much for inviting me.
Well, pleasure is all ours. Kathleen has just read a short version of your bio, which is already very impressive, which spans academic training in economics, expert consulting, and extensive engagement with competition authorities. Can you tell us a little bit more, in your own words, how you were drawn to antitrust economics initially?
Yes, that's a very good question. That just brought my memory back to my professor, Professor Jean-Jacques Lafont, the founder of IDEI and lately became Toulouse School of Economics. And he initially advised me to do competition and regulation to start my thesis. Then I was fully inspired by Professor Jean Tirole, who won the Nobel Prize with his two-sided market and platform economy. So antitrust economics is on the subjects of industrial organization that Toulouse is well known for. So there's also an area that connects the real world with the academic research, which is the foundation of consultancy.
So how did your professional path lead you to a focus on Chinese competition issues?
Well, that's another interesting question, Kathleen. I was very lucky, frankly, to work with very visionary people from my early stage of my career. For example, Professor David Evans, who is the first prophet, told me that China will have a promising market for consultancy. So I fully believed in him because he was the one who brought in the competition work to Europe and developed the whole market for LECG. That's the first firm I worked at. Like many other young economists, and I started working on the US and the EU matters fully, on the foreign matters. But later on, I found, Chinese antitrust monopoly practice is the area I'm fully interested in. So I start, with several business trips to China, and also I worked on several global mergers that give me some background to start at an early age.
So Kathleen mentioned the State Administration for Market Regulation, which is SAMR, China's agency, which is the nation's primary antitrust regulator following consolidation of functions in 2018. But your practice went back way even beyond that, right? In your observation, has the role of economic analysis changed over the years, alongside the changes of agencies and through your engagement with Chinese competition agencies, including SAMR and others?
Absolutely. So looking back more than a decade ago, Chinese Competition Authority has changed from MOFCOM, SIC, and DRC, and converted to a single agency, State Administration for Market Regulation, which is also called SAMR. And the role of economic analysis has already undergone a very profound and significant evolution. For example, from the very beginning, its role evolves from early stage of technical reference to a core decision-making element. And nowadays, economic analysis becomes the center of the decision-making process. And regulators often refer to the economists' opinions and also, ask the economists to play as the external expert for them on the global mergers, on the investigation against the abuse of dominance conducts or investigation of the cartels. So I would say, evolution is a natural outcome of China's market development, and the legal system is getting more and more matured, and that also reflects the growing professionalism and also the influence of China's antitrust agencies in the global competition community. So looking ahead, so when the digital economy evolves and deepens, the international case loads increase, and the economic analysis becomes, more important and push the antitrust practice towards a greater sophistication and transparency.
So based on your observations, what are the antitrust or competition enforcement priorities now in China? And how has economic analysis shaped those priorities in areas like merger control, abuse of dominance, or digital platforms?
Yeah. So the raising of the merger filing threshold has led the antitrust authorities to prioritize this regulatory resource towards the very important of the key sectors. For instance, the industries such as energy, semiconductor, or the pharmaceuticals and transportations have consistently maintained the focal point for the merger reviews. More importantly, with the introduction of the horizontal merger guidelines and non-horizontal merger guidelines, the sophisticated and also comprehensive analysis framework was introduced and also has been established in the merger review process. In the review of the high-profile cases, so beyond the application of the regular methodologies, for example, calculating the market share, HHI, and other quantitative tools such as GAPI was used in the horizontal merger reviews, and also provides the critical evidence for the authority to evaluate the unilateral effect. And that also shifts the focus from simply relying on the market share to the more scientific and also more reliable results of understanding the anti-competitive concerns.
Sounds like many of the enforcement priorities are aligned with the global trends or some other focuses in other jurisdictions. But are there any practical or even conceptual focuses in Chinese competition enforcers' current thinking that you have observed because you talk to them? What are those focuses that outsiders may have missed out or misunderstood?
That's very interesting and important question, Anora. I would like to interpret into two categories. The first is the merger review. I think most of the practitioners would be very interested about, because most people will think that China's merger review is not so clear and it looks like a black box. But my understanding is it's not black box as long as you understand the patterns and the logic behind it. So China's merger review system operates on the very distinct framework that reflects a very unique legal, economic, and political landscape. unlike the other jurisdictions such as US or EU, China's approach integrates multi-dimensional considerations. It blends the traditional antitrust principles with the broader industrial and also social political objectives. In another word, that China's merger review follows a strategical balancing pattern that reinforce the competition rules while still considering and aligning the outcomes with the broader state objectives. For example, industrial upgrade, self-reliance, and social harmony. So this creates a predictable but also distinct pathways for the transactions, especially when undertaking, when you understand the policies context, it's very, very critical, for the smooth and very desirable outcome of your merger filing. The second category is platform economy. So the China's approach of regulating the platform economy is very advanced, I would say. It's moving well beyond the reliance of the fines or the penalties. So given the nation's vast market size, the platform economy developed very rapidly in the past decades, and primarily in the very essential consumer sectors, for example, the e-commerce, the food delivery, transportation, and ride-hailing. Consequently, the regulators place a high priority on this enforcement agenda. So in year of 2021, China introduced the first dedicated anti-monopoly guidelines for the platform economy. The enforcement actions have been very decisive, including blocking the merger of Huya and Douyu, that's a game streaming platforms backed by Tencent, and also imposed significant fines against Alibaba, Meituan, the food delivery platform. Importantly, that China's regulatory framework isn't just focused on the exposed correction, and the authorities also provide the guidance, a series of the compliance guidelines to help the platform to establish the self-assessment and also internal compliance system that builds the comprehensive and also predictable regulatory framework that can cover the whole entire spectrum of the ex-ante prevention and ex-post enforcement. So this integrated or mixed approach aim to have a very effective and also very successful approach to identify the anti-monopoly or the monopolistic risks, but still maintain the very stable and orderly development of the whole industry. So that's why people are saying, let the bullets fly. That means that you should let the company or the industry evolve and let them grow instead of putting too much restriction before the innovation happens.
That's very helpful. Vanessa, maybe let's get to some of the specific type of cases that in which you had interaction with agencies with, starting with merger reviews. So in a merger case before SAMA, where do economists like yourself and economic analysis that you do add the most value? Is it in defining relevant markets, assessing competitive effects, or quantifying efficiency? And how are those analyses received within SAMR?
Yeah, so I could provide my perspective from playing both roles of helping the filing parties preparing the economic evidence and economics experts report. And also I helped the SAMR, the MOFCOM, to review the global mergers as their external experts. So based on my experience, economic analysis add the value to the assessment of the anti-competitive effect. For example, for mergers, the tools such as the UPP or GAPI and the merger simulations, sometimes that it provides the quantified unilateral effect, and it also moves the review beyond the speculation of the test, whether the core theory harm holds. So when defining the relevant markets, qualitative economic analysis is often used. And for example, the demand substitution, the supply substitution will be considered. And for the efficiency, although we could quantify it, but it has been treated very cautiously. So the regulators often require very clear and merger-specific and verifiable consumer benefit to support the result. So these analyses are not just like accepted, but also being integrated in the Summers merger review process. The horizontal merger guidelines and non-horizontal merger guidelines have specifically endorsed them. And the Summers case handlers, sometimes they are the lawyers and sometimes they have the background of the economics training. And they could also refer to the international consultants, just like me and many other of my fellow colleagues. They routinely incorporate the economic analysis and evidence even in their decisions. So the focus is on the robust and quantifiable assessment of the serial harm, and also making this at the primary arena where the economics shapes the outcome.
So in both roles, when you're representing the merging parties or when you've been retained as an outside expert by SAMR, what does the economist to economist dynamic look like when you're engaging with SAMR's internal teams? So for example, are there collaborative exchanges on models, data, or methodologies?
Yeah, that's a very interesting process, I would say. As a person who experienced, from both sides, I would call it like it's a one-way process. So fighting parties experts can always submit the models, the data, along with the methodologies in the economic expert report or white papers to explain certain issues involved in the merger. But the agencies, even their internal economists or like external economists, they set their own analysis. So sometimes there's opportunities, for both parties, both sides of economics, to sit together, to meet and clarify the models, the data. I would call it like it's more conversational rather than like a hot top cross-examination. But it doesn't always happen in all the cases. So it really depends, case by case.
So let's talk about another role that you've played, which is a testifying expert. And it's hard to be a testifying expert anywhere. You've submitted expert reports and testified before not just SAMR, but also MOFCON, another agency, and also provincial courts and the Supreme People's Courts in China. What kinds of economic questions do authorities or courts typically ask for your expert opinions on in those forums?
Yes. So Anora, I think you just emphasized a very important issue here. You know that in China, we don't have to go to the court for the merger reviews. So there's no litigation associated with the merger review. So the core of the merger review is to predict the transaction's impact on the future market structure. And the authority is key inquiry to the economist or to the expert will focus on the key assumptions of the quantitative economic analysis and the reasoning process. But on the other hand, the litigation is totally different. So the court's question will center on the identifying and quantifying the competition harm that has already happened. So that is more on the fact and effect. So, whether the theory of harm is credible is the center question. So, for example, in the merger review, MOFCOM or SAMR, they may ask, under what conditions would the post-merger foreclosure become profitable? Or what's the basis for the key assumptions of your economic model for foreclosure incentive analysis? But in abuse of dominant case, the court may ask, how did the alleged conduct have the anti-competitive harm, or were there other non-conduct factors ruled out, or is the sample representative, or could there be another, selection bias? For specific issue like excessive pricing, a typical question would be, how was the benchmark of the fair price calculated? So, I mean, it's totally different setup, and then the logic and also strategy would be different.
So, being a testifying expert requires such a comprehensive set of skills. What have you learned the most from your experiences as a testifying expert in Chinese courts?
Well, I would say, Kathleen, as you are also economist, academic credential is the key. So, to my understanding, that consultancy is a way to transfer academic knowledge and findings to the industry that can be used as a court or before the agencies. So keeping the academic research or publication would be the most beneficial way for becoming a experts that can convince the audience. I would say like judges or jury. Teaching at the academic institutions would be also helpful to build the effective testimony. For example, as a court, I never try to teach the litigator or the expert of the opponents, but I would rather teach my audience, the other judges. So just as my students when I taught at universities. So I think that, teaching experience would be very valuable in our industry as a consultant, testifying expert. And I truly enjoy the whole process of teaching, while testifying.
Are there any cultural or institutional differences that shape the interpretation or application of economic evidence in antitrust matters in China?
Yes, I would say different countries will handle the numbers and the data or the interpretation of the economic reasoning in a very different way, especially in the antitrust cases. But they have their own legal rules and goals, and which can affect that how they use the economic data. But the basic economic methodologies and also the reasoning behind all these antitrust cases would stay the same everywhere, just like how market works and how the theory harm is established. So my interpretation is we always use the same toolbox, but the different jurisdictions may choose different tools to fit the different local rules.
We've talked a little bit about the past and also from your current day-to-day job and the learnings. Now let's look ahead a little bit. As we've said before, China's competition regime continues to evolve and is evolving. So that's including legal and policy changes and enforcement trends. Where do you see the role of economists becoming even more important in the next perhaps 3 to 5 years?
Yes, I'm not a prophet, but I could probably give you some of my observations and predictions. So in in China's evolving antitrust landscape, economists will play very indispensable roles down the road in the 5 years, in the 10 years, especially in the digital market regulation, in the merger review, or the remedy design, investigations or litigations, including the damage quantification. But I would like to say that we need a rigorous economic analysis. So, because the economic analysis become the center to convince the regulators to support the claims at the court and to defend the corporate conduct and also align the enforcement with a global standard. So I encourage all the economists who may have the interest in Chinese antitrust, just, put your effort and put your time of following all these developments, and you will see a different world.
That's very interesting. Do you have any other advice that you would offer economists who want to specialize in antitrust work in China?
To learn Chinese?
I think that's very important advice. Yeah, because at the court, it's very important that you testify in Chinese. That can save the time for the judges to understand what you are saying. I mean, with the interpreter, your communication can be lost in the translation. But as an economist, my core advice is master both a global analytical framework with the China's unique institutional context. So that can be broken down into 4 categories. 1, build the expertise through rigorous academic research. 2, engage locally. You should follow Summers guidelines, contribute to the public consultation, analyze the Chinese case decisions, and understand how the public interest shapes the outcomes. 3, the bridge communication. You learn to present complex economic argument in a very clear way to the regulators, to the court and corporate clients, that in a way aligns with the China's legal system and the policy language. 4, stay adaptable. I know that's Kathleen, and both you and me, we are based here in the United States. I also practice in Europe, but I consider myself as an international citizen. So economists should navigate both rigorous economic analysis and also the regulatory nuance. And for people who can manage both would be very or most valuable, either in the agency or in the consultancy or in academia. So once you have everything, and you'll be the best person to ask for. So I would hope that, in the next 10 years, probably 5 years, you'll be the one sitting in my chairs to answer questions of the other economists.
Thank you, Vanessa. This has been very helpful, and thank you for sharing the many valuable experiences that you've learned. Now, since we have you, we usually take the opportunity to give our audience a little bit more insight into you as a person as well. So as we wrap up this conversation, I want you to share with us perhaps one thing that people would not know about you if they had only worked with you or known you professionally.
Well, that's a very good question. I have 3 girls, 2 daughters, 17 and 13, and a 5-year-old dog, which is Were Fox Terrier, and named after the famous animation Tintin. It's Tintin's pet in that animation. It's called Snowy.
It's very cute. You have a very fun house, I imagine. Now let's turn to a segment we call Curious Hat.
And now it's time for the Curious Hat.
The rule of the game is very simple. You give us a number, economists, you can do that, just between 1 and 21, and we'll give you a corresponding question.
Number 5.
5. Oh, I guess that's a given. Are you a cat person or dog person? Or neither, and why?
I'm definitely a dog person. I treat my dog almost like my daughter. So I pet her and walked her. She's a COVID dog. So my daughters begged me to have a dog, and we have searched the whole country to find exactly the same dog, because my husband is allergic to the furs, so we cannot have anyone. We don't have many choices. But Were Fox Terrier, as a suggestion for many dog lovers or someone who is considering adopting a dog, that Were Fox Terrier is the one is allergy free, so you can safely have the dog at home. And we did enjoy a lot of time with her.
Wow, that's very helpful. I'm a cat. I wouldn't say owner. I live with a cat. I would advocate for anyone who is allergic to dog hair. Perhaps you're allergic to dog, you're allergic to cat hair either, as well. So I guess that's a lost cause there. Thank you for sharing your stories and your learnings with us, Vanessa. Until next time.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.